This video is now the part 3 of Rule 65, Certiorari, Prohibition, and Mandamus. So we'll go now to this topic, distinguished Rule 65 from Rule 45. Your Rule 45 is your appeal by certiorari, or what they call now your petition for review on certiorari, and from your judicial power. Your judicial power is your Article 8, Section 1 of the 1987 Constitution. Isama na rin natin sa discussion this one. What are the exceptions to the filing of motion for reconsideration before filing your Rule 65? So we're going to distinguish now Rule 65 from Rule 45. Your Rule 45, that is your appeal by certiorari, or what you call now a petition for review on certiorari. And your Rule 65, that is your petition for certiorari. Again, your Rule 45, that is a mode of appeal. Your certiorari under Rule 65, that is a special civil action. So first, when we talk about Rule 45, when do you file it? What is the period? You file it within 15 days. 15 days from when? 15 days from notice of judgment or final order appealed from. And then if you filed your motion for reconsideration or motion for new trial, then you file it within 15 days from the denial of the MR or motion for new trial. Basis, that is your Section 2 of Rule 45. How about your Rule 65? When do you file it? The period is not later than 60 days. 60 days from when? 60 days from notice of judgment, order, or resolution sought to be assailed. Basis, that is your Section 4 of Rule 65. Is extension allowed in Rule 45? Answer, pwede. That is very clear according to your Rule 45, Section 2. The Supreme Court may take note of the word may, for justifiable reasons, grant an extension of 30 days only within which to file the petition. How about in certiorari? Tinanggal na yung provision na yan. Extension can only be granted under exceptional cases. Take note that the general rule is that the 60-day period is inextendable. You cannot extend it. But if that is the general rule, ano ang sabi natin? Palaging may exception. But the exception is it is subject to the sound discretion of the court and only under exceptional circumstances. Again, only under exceptional circumstances and always subject to the sound discretion of the court. So ulitin natin, what is the general rule? The general rule is your petition for certiorari, it must be filed strictly within 60 days. 60 days from when? From notice of the judgment or from order denying the MR. But is there an exception? There is. Under exceptional circumstances and subject to the sound discretion of the court, said period may be extended. So what are those recognized exceptions? Number one is if there is a most persuasive and weighty reasons, or if you want to relieve a litigant from an injustice not commensurate with his failure to comply with the prescribed procedure, if there is a good faith on the part of the defaulting party by immediately paying within a reasonable time from the time of the default. Number four is if there is an existence of special or compelling circumstances, the merits of the case, there is a cause that is not entirely attributable to the fault or negligence of the party favored by the suspension of the rules. If there is a lack of any showing that the review sought is merely frivolous and dilatory, or the other party will not be unjustly prejudiced thereby, or if there is fame, that is your fraud, accident, mistake, or excusable negligence without appellant's fault, if there is a peculiar legal and equitable circumstances attendant to each case, in the name of substantial justice and fair play, the importance of the issues involved, and in the exercise of sound discretion by the judge, guided by all the attendant circumstances. So please be guided by these recognized exceptions. So in Rule 65, what is the effect if you are going to file your petition for certiorari? Sagot, it will not stay the judgment or order subject of the petition unless enjoined or restrained. That is very clear according to Section 7 of Rule 65. Again, ulitin natin ha, that even if you are going to file your petition, the effect is it will not interrupt the course of the principal case unless there is a TRO or a writ of preliminary injunction has been issued. How about in Rule 45? If you file your appeal by certiorari, the effect is it will stay the judgment appealed from. Who are the parties? In your Rule 45, the parties are the original parties with the appealing party as the petitioner and the adverse party as the respondent without impleading the lower court or its judge. That is very clear according to your Section 4 of Rule 45. How about in Rule 65? Ano ang sinabi natin? Our respondent in Rule 65 is the tribunal, board, or officer exercising judicial or quasi-judicial functions. That is very clear according to your Section 5 of Rule 65. When the petition filed relates to the acts or omissions of a judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person, the petitioner is your private respondent and the tribunal, board, officer, etc. is your public respondent. So what is the duty of the private respondent? The duty is to appear and defend in his behalf and in behalf of the public respondent affected by the proceedings. And if ever there is a cost awarded, then it shall be only against the private respondent and not against the judge, the court, the quasi-judicial agency, the tribunal, corporation, board, officer, or person impleaded as public respondent. How about your public respondent? Your public respondent, again, is the tribunal, the quasi-judicial agency, the judge, the court, corporation, board, officer, or person. Unless otherwise specifically directed by the court where the petition is pending, your public respondent shall not appear, nor shall he file an answer or comment to the petition. If the case is elevated to a higher court by other party, the public respondent shall be included as nominal parties. But again, unless there is no order from the court, the public respondent will not appear or participate in the proceedings. Next, in Rule 65, what is the rule? You have to file your motion for reconsideration. That is a must. That is a condition precedent subject to exceptions. So again, it is a well-settled rule that your MR is a sine qua non condition before you can file your petition for certiorari. What is the purpose of that? The purpose of that rule is you want to give the lower court an opportunity to correct itself. But is that rule absolute? Again, subject yan to exceptions. It may be dispensed with if petitioners are able to show a concrete, compelling, and valid reason for doing so. How about in Rule 45? Is MR also a sine qua non condition? Hindi. It does not require a prior motion for reconsideration. 1989 bar exam question. Well settled is the rule that before you can file your petition for certiorari under Rule 65, you have to file your motion for recon to give the judge an opportunity to correct an error. An omission to comply with this procedural requirement justified a denial of the writ applied for. So question, when can you dispense the motion for reconsideration? Answer, when the order is a patent nullity, as where the court ako has no jurisdiction, where the question raised in the certiorari proceeding have been duly raised and passed upon by the lower court, or are the same as those raised and passed upon in the lower court. When there is an urgent necessity for the resolution of the question and any further delay would prejudice the interest of the government or the petition or the subject of the action is perishable, where under the circumstances a motion for recon would be useless, where petitioner was deprived of due process and there is an extreme urgency for relief, where in a criminal case relief from an order of arrest is urgent and the granting of such relief by the trial court is improbable, where the proceedings in the lower court are a nullity for lack of due process, where the proceedings were ex parte or in which the petitioner had no opportunity to object, or where the issue raised is one which is purely of law, or where public interest is involved. So for this exception to the filing of MR, better if you can memorize 3 or at the most 5, because again, it will come handy. So again, the answer is it is not always fatal because there are exceptions. And what are those exceptions again? Number 1 is the question of jurisdiction was already raised before and decided by the respondent court. Public interest is involved in case of urgency. Order is a patent nullity. The issue is purely of law and deprivation of right to due process. In Rule 65, if the petition is sufficient in form and in substance, what will the court do? The court shall order the respondents to file their comment. That is very clear according to your Section 6 of Rule 65. Ano ang sinasabi dyan? The court shall issue an order requiring the respondents to comment on the petition. And according to your Section 8, after the comment or other pleadings are filed, the court may hear the case or require the parties to submit memoranda. And if the court finds that the allegations of the petition are true, then it shall render judgment. Is this also the same in Rule 45? Answer, no, because the review by the Supreme Court is discretionary. Section 6 reads that a review is not a matter of right under Rule 45, but of sound judicial discretion, and it will be granted only when there are special and important reasons therefor. Another distinction is the grounds. Ano ang grounds in Rule 65? That is an error of jurisdiction. You will be raising questions of jurisdiction, whether the respondent acted without jurisdiction or in excess of his jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction. That is your Section 1 of Rule 65. How about in Rule 45? What you will be questioning or what you will be raising is only questions of law. That is very clear according to your Section 1 of Rule 45. Next, in Rule 45, what are you seeking to review? You want to review the final judgment or the final orders. That is very clear in Section 1 of Rule 45. You are going to file your appeal by certiorari from a judgment, from a final order or resolution. Is this also true when you talk about Rule 65? Answer, ano ang sinabi natin? Your certiorari or your Rule 65 may be directed against an interlocutory order of the court, or even if there is a judgment but the judgment says that it is not appealable or there is no appeal or plain speedy remedy available in the ordinary course of law, then you can resort to Rule 65. Ang ginawa nating example dyan is your small claims cases. Ano ang sinasabi ng Section 24 for your small claims cases? The decision is final, executory, and appealable. So in this case, what is your remedy? Your remedy is Rule 65. So this is in accordance with your Section 1 of your Rule 65. Last distinction, remember that your Rule 65 is an original action. It is not a mode of appeal. In fact, it is a special civil action. How about your Rule 45? Your Rule 45 is a continuation of the appellate process over the original case. So here is a summary of what we have discussed. Ito din, palaging tinatanong sa bar exams. Differentiate Rule 45 from Rule 65, and better if you can memorize 3 or 5. You start with the grounds and then the period and then what is the effect if you are going to file Rule 45 and Rule 65. So let's compare now Article 8, Section 1 of the 1987 Constitution with your Rule 65. So ano ba itong Article 8, Section 1? That is your judicial power. Let's read. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion that amounts to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So if you're going to compare that to your Rule 65, parang parehas lang. Bakit? Sa Rule 65, ano ulit ang ground? That is error of jurisdiction. That is the same ground if you are going to file your certiorari or if you are going to file your prohibition. Ano ang sinabi natin? Similarities ng certiorari and prohibition, they have the same ground, error of jurisdiction. And also, who is your respondent in certiorari and prohibition? That is your corporation, tribunal, board, or officer exercising judicial, quasi-judicial function, for certiorari, and for prohibition, exercising judicial, quasi-judicial, or ministerial functions. But how about in the 1987 Constitution? That is broader in scope. Bakit? Kasama na dyan si any branch or instrumentality of the government, even if that branch or instrumentality of the government does not exercise judicial, quasi-judicial, or ministerial function. So, yan ang kanilang difference. So, if you want to raise constitutional issues or if you want to review or prohibit or nullify the acts of the legislative and executive acts, then you can use your certiorari power under the Constitution. So this was asked in 2008. You compare the certiorari jurisdiction of the Supreme Court under the Constitution with that under Rule 65 of the Rules of Civil Procedure. So you already know how to answer. Just go to the ground. The ground again is error of jurisdiction. But who is your respondent in Rule 65 and who is your respondent in certiorari jurisdiction under the Constitution? Again, hindi yan limited only to those exercising judicial, quasi-judicial, or ministerial function. You can use that against any branch or instrumentality of the government as long as they are acting in excess or without jurisdiction. So, again, if you want to prohibit or nullify the actions of legislative and executive officials, or you just want to raise constitutional issues, then you can use the certiorari jurisdiction of the Supreme Court under the Constitution. So this is the end of the video. Thank you very much for watching.